Have you ever pondered on the intriguing question of how the South African law of evidence has evolved over time? This is a fascinating subject, rich in history and full of unexpected twists and turns. In the beginning, the South African law of evidence was a product of the Roman Dutch law, heavily influenced by the practices and principles of the Roman and Dutch legal systems. This period stretched from the 17th century, when the Cape of Good Hope became a Dutch colony, until the early 19th century. During this time, the law of evidence was largely unwritten, based on custom and precedent, and heavily influenced by the principles of natural justice. The British took control of the Cape in the early 19th century, and with them came the introduction of English law. However, this didn't mean an immediate and complete overhaul of the existing Roman Dutch law. Instead, an interesting fusion began to take place. The South African law of evidence started to incorporate elements of English law, particularly in areas where the Roman Dutch law was silent or unclear. Fast forward to the 20th century, a period of significant change for South Africa and its legal system. The law of evidence began to evolve more rapidly, not only incorporating the principles of English law, but also adapting to the unique social, political, and cultural context of South Africa. The development of precedent-setting cases and the codification of certain aspects of the law started to shape the modern South African law of evidence. The advent of the democratic era in South Africa in the 90s brought about further changes. The Constitution of South Africa, adopted in 1996, now plays a pivotal role in the law of evidence. The Bill of Rights, in particular, has a significant influence on how evidence is collected, presented, and evaluated in the courts. The principles of fairness, equality, and justice enshrined in the Constitution now underpin the South African law of evidence. Today, the South African law of evidence is a unique blend of Roman Dutch and English law, shaped by the country's history, culture, and constitution. It is a living, evolving system that continues to adapt to the changing needs of South African society. To summarize, we have journeyed through the evolution of the South African law of evidence, from its roots in Roman Dutch law, through the influence of British rule, the significant changes of the 20th century, and the impact of the democratic era and the Constitution. We've seen how this complex legal system has been shaped by history, culture, and the principles of justice, and how it continues to evolve in response to the changing needs of society. This is a testament to the resilience and adaptability of the law and its unwavering commitment to fairness and justice. Whether you are a law student, a legal professional, or someone with a keen interest in the law, understanding the evolution of the South African law of evidence provides a fascinating insight into the country's legal system and its commitment to upholding the principles of justice.